Hello, everyone. Good afternoon. We are just waiting for a few more people coming through the waiting room. We'll begin in one moment. Okay. Good afternoon, everyone. I think we'll begin now. So good afternoon, everyone, and welcome. My name is Roisin Pillay from International Commission of Jurists. I'm the Europe and Central Asia Regional Director for ICJ. So welcome to this discussion on the recent report of the Moscow Mechanism of OSCE on violations of international law committed following the Russian invasion of Ukraine. This meeting is hosted by the International Commission of Jurists, and as many of you know, ICJ is a global human rights organization of judges and lawyers, and we work for the protection of human rights through the rule of law. And amongst other things, what this means is we work to try to help ensure that international law, including international human rights law and international humanitarian law, is effectively implemented in practice, and that there is accountability and effective remedies where it's violated. And of course, these are some of the most pressing issues following the Russian Federation's invasion of Ukraine and in light of the ongoing conflict there. So we're here to discuss the Moscow Mechanism's report regarding violations of international law during the conflict. This report is a really important step in the efforts underway to ensure accountability for violations of international law during the conflict. It presents really a meticulous analysis of the potential violations of international humanitarian law, international human rights law, and of crimes under international law committed during the first phase, at least, of the conflict. It was a report published at high speed and dealt with the first 5 weeks following the invasion. And the report analyzes also the avenues available for accountability for these violations. And I think it's particularly valuable, this report, because it's the first of the international mechanisms to provide an authoritative and comprehensive legal analysis of these issues. Others, of course, will follow it. The International Criminal Court has opened an investigation. We have the Commission of Inquiry of the UN Human Rights Council now beginning its work. Already there are, of course, the very helpful reports of the OHCHR monitoring mission. And both the International Court of Justice and the European Court of Human Rights have processes open before them, and there are also national investigations underway. But the Moscow Mechanism report is a really important step that will inform the work of all of these mechanisms. So in the discussion here today, we hope to look at what the report tells us about violations of international law during the conflict, and also what more is needed for effective investigation, accountability, and remedies following this report. And we're lucky to have 3 really excellent and expert speakers for our panel today. Professor Marco Sassoli, who, amongst many other things, is one of the 3 members of the Moscow mission mission. Professor Andrew Clapham, Professor of Law at the Graduate Institute of International Development and Development Studies, and Mariana Katsarova, amongst also many other things, founder of the NGO Raw in War and a human rights investigator with extensive experience in the region. And so we'll hear presentations from each of our speakers, and then have some time for questions and answers. So I'm really happy to see we have a large number of people attending the discussion today. And because of that, I think what we will try to do is we will ask everyone, please, for your questions, to write them in the chat. And of course, no need to wait until after the presentations. As you think of questions, please put them in the chat, and I will then put them to the speakers after the presentations. The chat is also open for comments, for relevant information you'd like to provide. So please do use it. And I should say that we are recording this meeting, just for your information. So without delaying any further, I'd like to introduce our first speaker, and we're very, very pleased to have Professor Marco Sassoli, who is a professor of international law at the Faculty of Law of the University of Geneva, and also a commissioner of International Commission of Juris. He's a pro bono special advisor to the prosecutor of the International Criminal Court, and he's worked for many years also for the International Committee of the Red Cross, both at headquarters and in the field, and has published very widely on international humanitarian law issues. So over to you, Professor Sassoli.
Well, thank you very much, Roisin. First, I should clarify that I'm no longer pro bono special advisor to the prosecutor, and probably, no, certainly I couldn't have accepted this mission if I were. And I was under the previous prosecutor, while the new prosecutor didn't need my services. So let us speak about the Moscow Mechanism, international humanitarian law, and international human rights law. Perhaps a very short mention of how we proceeded, and in particular the limitations. Our mandate comprised also to establish war crimes and crimes against humanity, and to designate those responsible and to bring the necessary information to mechanisms which could prosecute them. This was not possible, obviously, in this conference. Everyone understands that war crimes are committed by individuals, and we were obviously in no single case able to determine which individual committed those violations of international humanitarian law. And in addition, you need obviously someone who has the necessary knowledge and intent, or has command responsibility. But contrary to what most people think, command responsibility doesn't exist by the simple fact that you are the commander. And the ICC has clarified that, for instance, in the famous Bemba case. The next limitation was that we had only 3 weeks. This is inherent in the Moscow mechanism, which has the main advantage, the Moscow mechanism, that therefore you are the first ones who bring something out. And the mechanism exists and has been accepted by the Russian Federation in 1991. We had no access to Ukraine because OSCE considered that this is too dangerous. And frankly, the problem is, because we could have nevertheless gone because we are independent, the problem is, as they were no longer present, they could not take appointments, and therefore we would have been completely dependent on the Ukrainian authorities. We had also no expert support by the OSCE. We simply got money which we could use to hire someone, but obviously you will not be able, for instance, to hire a military expert for tomorrow. Then we didn't have any official cooperation by the Russian Federation, but we did our best to consult their media and their official declarations, which were quite useful. And finally, a limitation was that in this conflict, perhaps even more than in others, in all armed conflict, there's plenty of disinformation and propaganda, but here it goes beyond the parties to the conflict, but also in local and international media, and even in NGO reports, there was a lot of disinformation. And so it was quite difficult to weigh appropriately the information, to compare it, to consider what is credible and what is not credible. We were lucky that our mission took place after the experience of COVID, and therefore people were accustomed to work with Zoom, and it was even possible to speak with victims, even possible to speak with victims in shelters. So apparently there was electricity, because otherwise you cannot use Zoom. And NGOs and intergovernmental organizations, and there I must in particular mention the human rights monitoring mission of the United Nations, which was really very helpful. Helped us a lot, and the Ukrainian authorities provided us with a lot of information. Unfortunately, they did not agree that we speak with the military also for humanitarian law. It would have been very important, for instance, to know whether when a certain village was destroyed, Ukrainian forces actually defended that village, and if yes, if they defended every house in that village. So let us come to international humanitarian law, and there I have to make a preliminary remark, which raises already one of the great problems, which is what the lawyers call the separation between jus ad bellum and jus in bellum. That it is, in my view, but the mission didn't have to pronounce itself on this, absolutely clear that the Russian Federation committed an act of aggression against Ukraine, and therefore all human suffering in Ukraine, including if it was directly caused by Ukrainian forces, and obviously even if you defend the country or make a counterattack, you will kill civilians, hopefully in respect of IHL, therefore respecting proportionality and precaution. But all this would not have happened if Russia didn't attack Ukraine. But nevertheless, humanitarian law treats both sides of the conflict equally. And this is very important for the future of humanitarian law, because we have to be conscious, although we are now impressed by this act of aggression, that every belligerent in every armed conflict around the world is absolutely convinced that he or she is right and the enemies are wrong. And if we had rules of humanitarian law which are different according to who is right and who is wrong, this would, in my view, be the end of humanitarian law as we know it now, but we would come back to temperamenta belli of the time of Grotius. So, what were our findings? Both the Russian Federation and Ukraine have violated international humanitarian law. Both have also in many instances respected humanitarian law. But you know, even when humanitarian law is respected, war is something to be avoided. However, the Russian Federation's violations were larger in scope and in nature. And I should perhaps first speak about those which were more difficult to find, which are the violations in the conduct of hostilities. Most of you know that international humanitarian law does not prohibit to kill or to destroy, but to target. And to know that, you should know what was in the building which was destroyed, who was in the building that was destroyed, and also to evaluate the proportionality, you should know the plan of the attacker, but also the measures taken by the defender. And in no single case were we able to do that. But we found a certain number of incidents where there was a clear violation of humanitarian law. Some people, for instance, journalists who were simply shot at on a bridge and were clearly identified, or the Mariupol theater and the Mariupol maternity clinic, and there it was possible to find that there was a violation, mainly because the explanation of the Russian Federation was clearly not true. While most of the time, what we could find is a pattern and a probability. And this is that so many houses, residential houses, schools, hospitals, police stations, water purification stations, religious buildings, electricity stations wouldn't have been damaged or destroyed, and there is clear evidence that they were, if the Russian Federation had complied with its obligations in the fields of distinction, proportionality, and precautions, in particular in places where there was no actual fighting between the two sides. Because, and this is obviously very hard for Ukrainians to hear, but this is simply the law. If the Ukrainians defend every house in a village is a legitimate target under IHL, but under jus ad bellum, obviously, there are no legitimate targets for an aggressor. But here we speak about IHL, so is a legitimate target of attack for the Russian forces. Also, then there can still be proportionality and precaution considerations. So, but there were also many buildings destroyed and damaged, somehow not very specific, but one and the other, say in Kharkiv or in Kiev, where there was no actual fighting. There can be military objectives there, but there cannot be so many military objectives in very strange positions. And therefore, we came to the conclusion that necessarily the Russian Federation had to violate at least one of these three principles in most of these attacks. When it then comes to the use of weapons, there's some hope for the future, because the Russian Federation was criticized for, including by NATO and by Western states, for using weapons which many of them before the 24th of February considered lawful, like cluster munitions. Even the NATO Secretary General mentioned cluster munitions among unlawful weapons. Now, Ukraine and Russia are not parties to the Oslo Convention, which outlaws cluster munitions, so apparently they consider, and I would agree, that cluster munitions are as such unlawful. Then the ICSE leads a campaign since 3 years about the use of explosive weapons with a wide area effect in densely populated areas. And there was a lot of resistance before the 24th of February by Western states. And once the war broke out, everyone, including Western governments, criticized, in my view correctly, the use of such explosive weapons with a wide area effect in densely populated areas. And the United States, for instance, is on record to consider that the use of white phosphorus is not prohibited, while they criticized such use of white phosphorus, in my view correctly, in Ukraine. Then the next large field is the law of occupation. We had a very large concept of occupation in the sense that every place which came even only provisionally under control of Russian forces was for us an occupied territory. And there, the law of occupation was in many instances violated, but was in some instances respected, in particular in those areas which came under the official control of the so-called republics of Luhansk and Donetsk. The Russian Federation introduced the legislation of those republics, which is unlawful. There were arrests without then any legal procedures. Some people were even disappeared. Some of them reappeared, some of them didn't reappear. And one of the greatest problems is, but this is an allegation, that Ukraine argues that 500,000 civilians have been forcibly deported out of the occupied territories. We cannot make numbers. It seems impossible that there are so many, but there are refugees, obviously, in Russia. And the question whether they were forcibly brought there is obviously a relative one. If you have a coercive environments, say Mariupol under siege, then people cannot freely decide whether they want to go to Russia or stay, because if they stay, they will die. Then to move to Ukraine, I think one of the greatest problems is the treatment of prisoners of war. Many were, and there were plenty of films about how they were ill-treated. Generally, Ukraine considered in the beginning of the conflict, which has again something to do with the mixture between international humanitarian law and the jus ad bellum, that every Russian soldier is somehow a criminal, and therefore it was the prosecutor who dealt with prisoners of war, which is not exactly what the Third Geneva Convention foresees. Obviously, there can be some who are war criminals, and if they are tried and sentenced, then they may be detained in a penitentiary, but until then, they are prisoners of war to be held in a prisoner of war camp. One point on prisoners of war where we have a concern with both parties is that the numbers are very low compared with the number of dead soldiers. And in Ukraine, they officially told us that the number of prisoners of war is a state secret. Russia did anyway not cooperate with us, but different sources spoke at the end of March about some 700. And 700 compared with 15,000 dead is too little. And this is very concerning because it would mean that some people may have been executed when they surrendered or are secretly detained. The International Committee of the Red Cross, at least while we were on our mission, did not have access, as it should under the convention, to those prisoners of war. And concern, which is also somehow linked to jus ad bellum, is that obviously the Ukrainian authorities, they appeal to all civilians to arm themselves with Molotov cocktails. But obviously, if every civilian or many civilians have Molotov cocktails, those civilians are no longer protected against Russian attacks. And if they are in their houses, the risk is that their houses will be attacked. And the proportionality evaluation, obviously, for the attacking Russian forces is very difficult, even if they wanted to do it, because they cannot know how many civilians in these houses have a Molotov cocktail and are waiting to throw it on them. Now, I moved to international human rights law, where we were confronted with three preliminary problems. The first is that Ukraine derogated very largely from the European Convention on Human Rights and the International Covenant on Civil and Political Rights. Russia did not derogate, but under the Hassan case of the European Court of Human Rights, it didn't have to derogate, because even if it doesn't derogate, it could invoke before the court, if this ever comes before the court, international humanitarian law, and even in cases where it violates human rights law. Then the Russian Federation, together with the United States and Israel, considers that human rights law doesn't apply extraterritorially. We consider with the great majority that it applies, and this has been decided by the International Court of Justice and by all human rights bodies. And the third problem was provoked by the European Court of Human Rights, which decided in Georgia against Russia too, and Bekoyeva case, that during the phase of active hostilities, persons are neither under the jurisdiction of the invader nor under the jurisdiction of the territorial state. So our solution to all this was perhaps not very elegant, but in 3 weeks you cannot do more, was that in those territories we considered as occupied, we could apply human rights law, while beyond that, we simply mentioned which human rights were violated, but we did not really attribute it to and say violated by the Russian Federation or by Ukraine. So the mission was not in a position to verify all the reported incidents, which may involve violations of human rights law. However, based on a thorough analysis of the reported incidents, it was able to come to three main substantive conclusions. First, it found credible evidence suggesting that violations of human rights law, including of the most fundamental human rights, took place during the first 5 weeks of the conflict, most in the areas under effective control of Russia, and particular in areas where it had control only for a shorter period. The most serious of these violations include, but are not limited to, targeted killing of civilians, including journalists and human rights defenders, mistreatment of civilians, including rape of women and girls, violation of the prohibition of torture, abductions, enforced disappearance, and deportation, as I mentioned, allegedly of large number of civilians. Second, the mission concluded that the impact of the conflict on human rights had gone beyond direct violations of human rights by causing a high level of destruction and by interfering with the provision of vital services such as healthcare or education. The conflict had made it very difficult for the Ukrainians to fully enjoy their human rights. And it had also made it difficult to Ukraine, which did nevertheless a very good job to try to guarantee a minimum, including of bringing food, electricity to the people in villages subject to the conduct of hostilities, also for public consumption purposes. They don't even admit that they did it, but the fact that they did it was in compliance with human rights law, and they were quite well organized as far as we understood. And thirdly, the mission established that while the conflict had affected all inhabitants of Ukraine, it had a particularly strong effect on individuals belonging to vulnerable groups, which are but not limited to women who experience various forms of gender-based conflict and non-conflict related violence, including rape, children who have their family lives disrupted, older persons and persons with disabilities who were often left behind and decided to stay behind without the necessary care and means of subsistence. And obviously the mission also confirmed that was not difficult, that the conflict had produced new vulnerable groups, especially refugees and displaced persons. Before finishing, just a word on accountability. Our general impression was that the accountability mechanisms exist. Perhaps one exception, and as I speak here in an International Commission of Jurists context, I would like to mention the idea of the ICJ to have the Syria mechanism and the Myanmar mechanism, that it becomes a general mechanism for all such situations, and that there is a place where evidence for future criminal procedures are concentrated and where national and international prosecutors can then get the necessary evidence. For the Ukrainian authorities made a great effort to start prosecutions and to start inquiries. We were a little disappointed when we asked them, are there any cases of Ukrainians you prosecute, you look into? And the prosecutor general said, yes, only Ukrainians who collaborated with the Russian forces. And the same thing is true on the Russian side, where there's also a commission on war crimes, but not one single person there is a Russian citizen who was prosecuted or was under investigation for war crimes. Finally, I think a very positive development in this conflict, and I hope that this will really show a change in attitude by states, is how much states considered that they must do something, and they took unprecedented measures to stop violations of international humanitarian law. Also, this was often mixed with jus ad bellum, because obviously they can also, in the framework of collective self-defense, help Ukraine to defend itself against the aggression. But each time there were new allegations of violations of humanitarian law, third states took new measures against the Russian Federation. And as you mentioned in the beginning, all existing mechanisms immediately reacted. I mean, the International Criminal Court shall send immediately a mission, and so we can hope that it will take less time than in the conflict between Russia and Georgia, where it took 14 years until the first person was indicted. Thank you very much.
Thank you so much, Marco, for that summary and overview of the report and the work of the mission. And it's the report is a fantastic piece of work. And you've also ended on an optimistic note that there is the international political will there to try to ensure that the international law frameworks work. And so we really hope that this can bear fruit for this conflict and for other similar situations where that hasn't always been the case in the past. So thanks so much, and we're looking forward to perhaps some questions and some discussion on your presentation later. I'd like to just remind everyone, and for those who arrived a little after the start, welcome, and just a reminder that if you have questions for Professor Sassoli or for any of the panelists, please write them in the chat. So far, I see one question, and I'm sure there are many more questions popping up in the minds of all the participants. So please put them in writing, and we'll put them to the panelists. But now I'd like to move on to our second panelist, and again, we're really delighted to have Professor Andrew Clapham. He's Professor of International Law at the Graduate Institute of International and Development Studies in Geneva. Since 1997, I think he's been with the Institute, and he's also a member of the UN Commission on Human Rights in South Sudan. Andrew is an honorary member and former commissioner of the International Commission of Juris. And some time ago in 2003, he was also advisor on international humanitarian law to Sergio Vieira de Mello, the UN Secretary General Special Representative in Iraq. And of course, he's the author of a number of books on international law. Professor Clapham, the floor is yours for commentary and thoughts on the Moscow Mechanism report and what comes after it. Thank you.
Well, thank you very much for inviting me to comment and to be part of this Q&A session on the OSCE report. I don't want to add to my bio, which you introduced at length, but I feel in the interests of transparency, I should say that I'm advising a task force for the Prosecutor General of Ukraine on ways to find accountability in Ukraine. So I'd just like to be clear about that role. So I'd like to start by congratulating Professor Sassoli and his colleagues on producing such a careful and useful report in such a short time span. I think it provides an amazing roadmap for anybody seeking to understand what the accountability challenges are for this conflict, and indeed for other conflicts. It's a sort of classic in its time as to how to break down a conflict into the different sorts of violations that are important, and indeed how to go about proving them. And I think the way that it draws inferences and it allows itself to come to some tentative conclusions is in a way a model for this kind of report writing. The three professors who wrote it, as has been said by Professor Sassoli, are not really prosecutors or judges or a jury. They seem to me to be explaining to a prosecutor what would need to be done to make the case before a judge. But nevertheless, their preliminary findings, I think, are very helpful in painting a picture of what the law is, what is being violated, and by whom. Now, with such a rich report, there's a danger that I get distracted into taking up sort of doctrinal points of interest for the classroom and pressing for detail. But I wanted to try and step back and point to some of the big picture issues which struck me as significant in reading the whole report, both for the way in which they conclude, but also a bit for the way that they said it. So there was a particular passage which struck me on page 29, and I'm quoting now. In view of the number of civilians killed or injured and civilian buildings destroyed, far away from where ground forces were actually fighting each other, and therefore every building defended by Ukrainian forces or civilians constitutes a military objective. They go on, it seems highly implausible to the mission that in each case in which civilians were killed, the military advantage sought was so important it justified the impact on civilians, which had to be expected in an urban area. It must be stressed, they say, that the unavailability of precise weapons does not play any role in the respect of the proportionality rule. If an attacker does not have sufficiently precise weapons to comply with the proportionality rule in case of a given attack, the attack is unlawful. And I think that's a really good way to summarize the fact that this massive destruction in urban areas cannot really be related, in their view, to any kind of military advantage. And therefore, we could go on to say that those who willfully made this attack on the civilian population or launched an indiscriminate attack in violation of this proportionality rule have committed a grave breach of Additional Protocol 1, which is a war crime, which could be prosecuted either in Ukraine or at the ICC or in any of the states around the world that have included this grave breach in their jurisdiction. And of course, that I might mention includes the United Kingdom under the Geneva Conventions Act. So there are multiple possibilities to prosecute those who have been involved in this massive destruction of civilian areas and the massive killing of civilians. And I think it's important to underline that what they've done is they've drawn an inference from the damage in its context. And I would just like to repeat the words of the Commission. It's highly implausible that this is not subject to war crimes prosecution. So let me turn to three questions that I'd like to put to Professor Sassoli based on the report. So the first refers to another passage that I found particularly striking. And it is at page 5, and it was alluded to in the introduction, but I wanted to read it verbatim. It says, Russia is the aggressor and therefore responsible for all human suffering in Ukraine, whether or not it results from violations of international humanitarian law, and even when it is directly caused by Ukraine, because even that would not have occurred if Ukraine had not had to defend itself from the Russian invasion. Now, it seems to me this is a reference to the obligation to provide reparation under the law of state responsibility, and it therefore covers all the death and destruction and damage caused by Russia in violation of that obligation. And I suppose, although it's not said explicitly, this seems to flow from a violation of the UN Charter and customary international law on the use of force. But the death could also constitute a violation of human rights and human rights law, as recently explained by the Human Rights Committee in the context of its para 70 of the General Comment on the Right to Life. Now, the report only references the fact that the death which flows from the aggression is a violation of the human right to life in passing. And this might seem like a bit of a niche interest. If the death has to be paid for, does it matter whether it's a violation of the Charter or a violation of human rights? And I'm going to insist that it does, because we're talking about accountability mechanisms. And all the deaths of Ukrainian soldiers and all of the civilians are violations of their human rights. And arguably a case could be brought before the UN Human Rights Committee that Russia has violated their right to life. You can't bring a complaint before any of the UN bodies as an individual that the Charter has been violated. And Russia is indeed a party to the optional protocol to ICCPR. So I would be really interested to hear from my colleague, Professor Sassoli, what their position was on the deaths caused by Russia as a result of the aggression. Are these human rights violations? And does it make sense to think about this as a human rights accountability question? The second question I wanted to put relates to the finding at page 5 that as of the 1st of April this year, only Russia and Ukraine are parties to the conflict, and Belarus and the NATO countries were not parties to the conflict at that time. And I suppose many people would consider they're still not parties to the conflict, although I have read some people suggesting they are. Reading the report, it doesn't seem that the experts considered this would make a great difference, because whether or not there are parties to the conflict, they have obligations to ensure respect for the Geneva Conventions, and if they were looking after prisoners of war, they would clearly apply the Geneva Conventions. But there's another part in the report on neutrality and the capture of maritime ships at sea, which seems to suggest that it makes a difference whether a ship is flagged as a party to the conflict or as a neutral party. And I wondered whether the experts had spent time thinking about this, and whether or not it really makes sense in the 21st century to be talking about the idea that Russia or Ukraine could capture enemy ships on the high seas, depending on whether or not this line has been breached between neutrality and party to the conflict. I really wonder if, as a result of the UN Charter, these ancient rules of belligerent rights, rights that a state is entitled to because it's at war, really exist anymore. And my third question goes to something which was introduced in the introduction, and that's the question of the prohibited weapons. And the report suggests that the experts consider that white phosphorus is prohibited as a matter of international law at page 43. And I would be really interested to hear a bit more about this. It wasn't clear to me whether the weapon is prohibited because it's used in a way which doesn't discriminate between combatants and civilians, or whether it was suggested that it was prohibited because it creates unnecessary suffering when used against a combatant, when there might be other alternative ways to attack the combatant, and therefore it is unnecessary suffering, or whether the weapon is just prohibited because it's prohibited and it's just a matter of international law and states seem to believe that. So that would be my last question, and I will end here by just reiterating how useful I think this report is for the victims of war, for those who are interested in accountability for the violations committed, and yes, more generally for those seeking to build a robust legal order to prevent these kinds of violations in the future. So thank you again for inviting me.
Thank you so much, Andrew, and for raising those important questions about the report regarding issues of human rights law, accountability and reparations, particular perhaps before the UN Human Rights Committee, and also regarding the parties to the conflict and prohibited weapons. So we'll come back to those perhaps after the presentations. I'd like now to turn over to our third speaker, and we're very happy to have Mariana Katsarova. Mariana is the founder and chair, as I said before, of the NGO Raw in War, which is short for Reach All Women in War. She is a human rights investigator, advocate, and an expert on combating human trafficking and violence against women in particular. She's also worked at OSCE in the past, where recently she led the mandate of the OSCE examination on the human rights situation in Belarus. And this is, of course, of particular interest to the Ukraine investigations and accountability mechanisms also. And she's also worked in Ukraine, where she previously led the UN Human Rights Monitoring Missions team in Eastern Ukraine as head of the regional office there. She's been advisor on human trafficking also to the UN High Commissioner for Human Rights, and worked with Amnesty in Chechnya and elsewhere. So With that, Mariana, I will hand over to you and to speak, perhaps give us your insights in particular about investigation and accountability and how it might function most effectively in regard to this conflict. Thank you.
Thank you very much, Roshan, for your introduction and for inviting me to be part of this incredible company speaking today. Professor Sassoli was my professor of international law. And of course, Andrew Clapham is an old colleague from Amnesty International many years ago when we were just starting. And I think we were starting with building ICTY at that time, or it was just about established. I thought, and I hope to be short, I hope my time would be used best to really talk as a practitioner, to highlight some challenges for accountability, and also to be the bridge a little bit with the question and answers to what's next after the Moscow Mechanism report. Of course, as Andrew also mentioned, I would like to start by congratulating the three professors and Professor Sassoli, particularly for the part of the Moscow Mechanism report dealing with violations of IHL, but also the whole report. I see it as a blueprint, and I see it as setting a framework for any other accountability reports, but also mechanisms, because it really is the framework within which investigators and further down the line prosecutors will be trying to establish responsibility for violations of the various branches of law, from international humanitarian law, criminal law, and of course, international human rights law. Well, for accountability, and Roshan, you mentioned the various, or at least some of the mechanisms that already have been established. The report itself outlines in the beginning of April, but since then, of course, several others started working or were established. It's a lot of international effort on all fronts, on the national level, on the global level, on the European level. And I think the Russian invasion of Ukraine and the current situation in Ukraine, unfortunately, through the tragedy of war, brought up this enormous activity on the international level. It brought up, in a way, it's marking a turning point for documenting war crimes and accountability efforts worldwide. And again, I was planning to mention it, and it's mentioned in the report. Professor Sassoli already spoke about it. The proposal by ICJ and also the government of Netherlands to look into ways of establishing a permanent independent accountability mechanism similar to or building upon the experience of the one on Myanmar and the one on Syria. And I think this is a great idea, and hopefully there will be some thinking and some fora where this could be undertaken. Because in terms of accountability, the most important thing is to have evidence, and to have evidence that are verified, that are solid. And this is, at the moment, there are all these efforts on documenting evidence. On one level, this is commendable, because there was no such efforts, for example, even on Ukraine in 2014, when basically the conflict began 8 years ago in the east of Ukraine. Somehow this was overlooked by, on the international level, by the international community. However, of course, this was recognized as an internal armed conflict. And here we have a situation of international armed conflict. So one of the issues again is we see unprecedented efforts by NGOs, by private firms, for example, on collection of user-generated evidence and open source intelligence evidence. While companies and groups like Bellingcat, but also local Ukrainian groups are involved in these, international companies. While this is extremely positive development, especially in a situation where not the Moscow Mechanism, not even the UN Human Rights Monitoring Mission, or any other is able to be on the spot of where violations were committed. It's at the moment, with the ongoing hostilities, using open sources and trying to collect evidence this way is extremely positive development. However, there are a few challenges, and I'm sure that they will be addressed as long as we go, and the conflict, unfortunately, is continuing, the war is continuing. For example, one of the major questions is whether such evidence could be used in criminal proceedings. There has been some positive already developments in this respect. As far as I know, they were used in trials in Germany, Finland, Sweden, I think also the Netherlands, and also by the ICC in the case of Al-Verfal, Libya, and also in the case of Al-Mahdi of Mali. However, this is not a usual practice, and what would be the take of the ICC in using an enormous amount of evidence obtained through open source and through user-generated evidence. But I understand from what I read that the ICC is actually interested in going in this direction and exploring, which would, of course, push the boundaries of how evidence is collected and used. I also understand that the Ukrainian NGOs, and I should really commend and express my admiration for the Ukrainian human rights defenders and NGOs who are really literally risking their lives at the moment and in the past 8 years, I should say, to collect evidence, to document the atrocities committed. They, I understand, have been, especially one of the major groups, which is called 5 AM, and it comprises 26 Ukrainian NGOs that are busy documenting war crimes at the moment, collecting evidence. The volunteers for this group has been trained mandatorily in the Berkeley Protocol on digital open source investigations. This is a very helpful and framework providing document, which is new, which came about in 2020. The Office of the High Commissioner for Human Rights was involved with the university, with the Human Rights Center in Berkeley, to actually set up the, to provide what, what are the necessary steps to take in order to really collect useful evidence through open source investigations. While some of the Ukrainian NGOs has been trained in that, there are at the moment 2 or 3 coalitions of NGOs in Ukraine that are collecting, documenting war crimes and evidence. I mean, one of the challenges, not only for collection through open source, but for any documentation of evidence, is really the need for coordination of efforts on all levels. And I think, every week or every day when I hear of the new portion of billions that governments are donating for, providing help with arms to the effort of the Ukrainian army, I'm thinking about God, if a fragment of these billions, maybe even in the millions or less, could be spent to support the efforts of the local NGOs in Ukraine, especially on documenting evidence of war crimes and human rights violations and crimes against humanity. This money need to be spent, of course, on training volunteers, because mainly, from what I know, the Ukrainian NGOs are using now new people, volunteers. A lot of the previous experts has gone either abroad or have joined the army. So they need to find new people to join their efforts and to train them quickly. Now, that requires funding, and that requires a very, concerned effort by the international community. In terms of coordination, and I mentioned it's not just on the national level, it's of course on the international level as well, but as we're speaking about the national level, for example, there are, as I know, several portals open by various authorities in Ukraine to inviting NGOs and human rights groups to submit evidence. So one is opened by the Office of the Prosecutor General of Ukraine, another one is opened by the Office of the President. Even the Ministry of Culture opened the portal where they're inviting submission of evidence on destruction of cultural heritage and cultural property. And also, of course, there is the ICC invitation to civil society to submit evidence. Of course, while this shows and is a good effort of such an unprecedented activity to make sure that all evidence are documented and received by the authorities and by the ICC, I think without careful coordination and clarification, what are the systems of preservation of this evidence, there is a risk and a challenge of the chain of custody, for instance, to be a huge challenge for submission of such evidence, and then how they could be used for criminal prosecution. There is, of course, another challenge, thinking about the Ukrainian authorities. Yes, already the first prosecution started. There is a young soldier, Shishmarin, I think is his name, who is already, the first proceeding started. He's charged for killing intentionally one pensioner, a civilian unarmed pensioner, in the outskirts of Kiev, in one of the small villages. I'm not sure whether it was Bucha or another one. However, what would be really helpful, and this is what Professor Sassoli and his colleagues reflected in the report, and what the Ukrainian NGO community has been speaking and advocating for already probably for several years, is harmonizing the Ukrainian national legislation with the norms of international law. And unfortunately, I think it's Article 438 of the Ukrainian Criminal Code is the only article which is quite general one, and which is called violations of the laws and customs of war. But this article is not really enough, because the provisions of international humanitarian law or international criminal law have not been properly unpacked and adopted in the Ukrainian national legislation, which in turn will slow pretty much any prosecution effort, because any prosecutor has to actually go and read the Geneva Conventions and try to figure out on each case how to take forward the case. I also know that there is a proposal, and this was in the report of the Moscow Mechanism, that there is a proposal in front of the president of Ukraine, a draft law implementing the international law principles in the national legislation, but it has been waiting for a year to be signed. And hopefully now that Ukraine is commendably engaged in starting already the prosecutions of war crimes, they could see it as a practical, overcoming a practical challenge for their own national prosecution. In terms of other challenges or questions that we need to address now in order to really have a body of evidence that could be used for accountability in criminal proceedings, I think, of course, it's very important, the whole issue of protection of victims and witnesses. And given how many national and international mechanisms at the moment, including the ICC, in some cases will be striving to interview the same victims and witnesses, let's say Bucha or Irpin, or when anybody gets to Mariupol, the same thing with the Mariupol maternity hospital or the theater. I think it's very important that there is a real coordination and also not to re-traumatize victims and witnesses, but also if we saw that actually on the investigation on Belarus as well. I mean, over time, also it's some victims and witnesses may not be willing to tell again their story. There should be a very productive coordination and cooperation between the NGOs, the international mechanisms, and of course the national prosecution, how this is done. ICC as well. Sometimes with the good intention, some, for example, civil society or other bodies may actually preclude accountability through criminal proceedings going forward in terms of how evidence are collected. In terms of the protection of victims and witnesses, again, I remember the experience of Chechnya, where the Russian soldiers, the Russian forces went into, and I was at Amnesty International at the time, and we were documenting case after case of extrajudicial executions, killing of civilians that petitioned the European Court for Human Rights. And I think, I'm not saying that it will happen in Ukraine, but obviously will be very important to protect, the victims and witnesses with kind of and especially here I'm thinking also about sexual violence cases that have been resurfacing now more and more in the war in Ukraine. Of course, without the witnesses and victims, any court proceeding would find it very difficult to proceed. And I don't exclude effort to eliminate these witnesses and victims. Also, efforts on protection of the identity of the victims and witnesses. Again, Russian and Belarusian hackers are one of the best in the world, and half of them work for human rights, and some other half actually work for against human rights. I may put it. So I think creating, how do we preserve the evidence? And sorry, yes. How do we preserve the evidence? How do we store them, archive them? OSCE through its accountability mechanisms, has, of course, a lot of experience and a very good methodology to follow. Of course, if there are, and maybe later I could even answer some of the questions, but one of the recommendations that I would make is that really for some kind of coordination body, which will help on all levels of investigation, of not duplicating efforts, of preservation of evidence, of archiving, and of how do you secure the databases used for storing, and also what are the security protocols for access and for provision of this evidence to future accountability mechanisms. And maybe finally to the European states, but to any other states, because I personally believe, and in the case of, we see it in the case of Belarus very much so, the universal jurisdiction efforts have proven to be most helpful in trying to bring accountability for the victims. And I think one very important task for the European states, and as I said, for any other, is to harmonize its own legislation and to make it possible and easy for universal jurisdiction cases to be taken up. Even countries which has taken up such cases have some homework to do on various crimes and implementing it in their own national legislation to make it easier for accountability. Thank you very much for now.
Thank you so much, Mariana. This was incredibly useful, and just on the practical barriers that there are to accountability and the real complexities that there are in the gathering and the storage of evidence, in ensuring that there is evidence that is admissible in court, and of ensuring coordination as well. And I think the message is that we really have to learn the lessons also of previous exercises of this kind. I mean, Belarus is perhaps one, but there are many other examples, and try to ensure that that coordination is there. And even with all goodwill and with the great efforts of civil society, of all of the different bodies, it is, we know from experience, I think probably extremely difficult to ensure. And indeed, ICJ has been advocating for a permanent mechanism to, in that regard, to improve that situation. So that's one way forward on this, that in the long term can be of interest. So thanks so much. I think perhaps we have a number of interesting questions coming up in the chat. But I'd like, I think, first perhaps to give the floor to Professor Sassoli in case he would like to address any of the questions and comments that were made by the other panelists, and then perhaps turn to some of the other questions.
Yeah, thank you very much. Well, I saw also what is in the discussion, and somehow we could have a good discussion until tonight around 10 o'clock about these issues. So I will be very short. Just a clarification, the quote made by Andrew Clapham, read by Andrew Clapham, comes from the proportionality section, and we don't say, and we couldn't say, there was no military advantage in these attacks, but simply the combination, and we explain in a specific section that we cannot distinguish distinction, proportionality, and precaution, but we can conclude, and not only highly improbable, but really it is not imaginable that the Russian Federation complied with the three principles together, which are obligations under international humanitarian law. I understand why Andrew Clapham presses on proportionality, because contrary to precautions, proportionality, to violate clearly the proportionality principle, is a war crime. So we don't say there's no military advantage in these attacks. This should be determined for every single attack, and is a very difficult thing, especially if Russia doesn't cooperate, and contrary to the Second World War, yes, which will not happen. I mean, Western states and Ukraine will not occupy Moscow and have all the archives if the Russians have records like the Nazis had. And so it will be very difficult to prove the plan, the advantage, what was thought, and therefore proportionality is probably a difficult thing to prove in a war crimes trial. Now, on the famous question of whether the death of Ukrainian soldiers without any violation of IHL is a human rights violation, I think yes, it is. Reparations, well, I would already be happy if there were reparations of the violations of humanitarian law, which never ever happened anywhere in the world to the full extent of the violations. And the same thing is for human rights law. But obviously, I mean, reparations, this is the old kind of reparations simply for the war. After the First World War, and some say this is what the starting point for the Second World War, Germany was considered to be responsible, as we wrote it, for everything which happened in the First World War, and therefore not only for violations of international humanitarian law. Now, does that make sense? Yes, why not? Go before the Human Rights Committee. Then the Human Rights Committee will have to clarify the relationship between what it wrote about violations of the right to life in an armed conflict, at least when it comes to conduct of hostilities, exists only if humanitarian law is violated, and killing a Ukrainian soldier is not a violation of humanitarian law. But at the same time, they said every killing in a war of aggression is a violation of human rights, which is technically correct, but they have to somehow to clarify how these two statements interact. That only Russia and Ukraine are the parties to the conflict, yes. Here again, we should not mix up jus ad bellum and jus in bello. In violation of jus ad bellum, Belarus put its territory at the disposal for attacks on Ukraine, but this does not trigger the applicability of IHL other than Article 1 common. And in conformity with jus ad bellum, many Western states provide weapons to Ukraine. This implies an obligation under Article 1 common, but does not make them parties to the conflict in the sense of international humanitarian law. I know, Andrew, your preferred subject is the famous capture of ships, which has an underlying important question: to what extent international humanitarian law or the laws of war provide rights, and in the law of naval warfare, traditionally there were rights. Now, should we distinguish neutral and ships of the parties? Where neutrality has become a nearly obscene term, and even the Swiss do not no longer want to, or many in Switzerland suddenly want to abandon it, as if war was not prohibited since at least 1945. So as if this was the first war. But that's another problem. Actually, when you read our section on naval warfare, you will see that that Russia did not comply with the traditional requirements, in the sense that it published no valid contraband list, it used force against neutral ships and did not confiscate them, and it's very unlikely that these were indeed military objectives. But obviously, if your suggestion means that both sides may no longer exercise rights, then I must say, let us assume that China delivers weapons to Russia. Do you really want to prohibit Ukraine to hinder those ships to enter Russian ports? I would have some doubts. And the alternative is to abandon the equality of belligerents and to say, obviously, the Ukrainians may do it, but the Russians are the aggressor, and therefore ex injuria ius non oritur. All this is legally possible to claim, but makes international humanitarian law increasingly unrealistic because the parties to the conflict in actual conflicts which happen somewhere in the world do not agree on who is the good guy and who is the bad guy. White phosphorus, well, I mean, you know, everything in law, or nearly, except the prohibition of torture, is a question of arguments. And so the three lines of arguments you make are possible, but I think there are good arguments to say that white phosphorus is not a chemical weapon, that it is not an incendiary weapon, but that it is prohibited because even if you use it against military objectives, because it is not meant as an anti-personnel weapon. So it's not a question about killing a soldier with white phosphorus, but rather if you use white phosphorus, there will be effects on the civilian population which are unacceptable and necessarily disproportionate compared with the advantage of using that white phosphorus. And again, we had the chance, because I understand as you are obsessed by war crimes, you must clarify that. While for us, it is sufficient to say, we cannot imagine a situation in which if a state complies with the obligation to take precautionary measures, it uses white phosphorus as a weapon when attacking military objectives. Now, the very interesting and justified remarks of Mrs. Gatsarova, I agree with nearly everything, in particular with the need of coordination between NGOs. As you also mentioned about NGOs busy documenting war crimes, that was also our problem. They all wanted to speak about war crimes. I think very few of them are really able to document war crimes. What they can document is violations of international humanitarian law, and then it becomes quite complicated to attribute those to an individual, and there I think the prosecutor has quite some work, but it is also important that new technological means facilitate this work. Now, on the Ukrainian legislation, I agree with you, but anyway, at least for me, this legislation couldn't be retroactive. So even if it is adopted, and I hope so much that it is finally adopted, it could not help in the cases of the past. Thank you.
Thank you very much, Marco. And I wanted to try to, we don't have a huge amount of time left, but I wanted to turn to some of the interesting questions in the chat, and perhaps to focus on those that relate to accountability. So there is a question from Anna Tarvahartiala, asking, addressed to Professor Sassoli, asking for your thoughts on the trials now launched in Ukraine, and whether the trials will remain in Ukrainian domestic courts or there will be international or ICC processes as well, which I suppose there will be, but that's an important question. There is a question from Vedran Rezak as to what are the lessons learned from the Bosnian War, which I suppose is a very big question, but I think feeds into some of the discussion already as regards learning lessons from other attempts to ensure accountability. There's a question related to this is a question from Fabian Wilches on the existence of non-international armed conflicts or conflicts happening in Ukraine besides the international armed conflict. Mr. Wilches says, it seems the report is not considering the possibility of the existence of non non-international armed conflicts and the implications this could have in terms of accountability and attribution. Any thoughts about non-international armed conflicts happening in Ukraine? And a question from the same questioner about mercenaries and other non-state armed actors supporting either any of the forces involved. Any thoughts on this in terms of accountability? So some of the complex issues there in regard to responsibility and accountability. A question from Ola Kvarnström from OSCE ODIHR. And this is a question addressed to Ms. Kasarova. Should prosecutors in other countries work on universal jurisdiction cases, quotes, by themselves, or should they coordinate with prosecutors in Ukraine? And yeah, this I suppose goes to the question of coordination that was raised already. So many questions there about the complexities and ensuring accountability, and I'm sure there's not time to address all of those thoroughly, of course. But would anyone like to try to address some of the points raised?
Well, if you want, very unfortunately, very shortly, the domestic prosecutions are a good idea, and it is very good that Ukraine does it. I was slightly astonished when I read that the prosecutor of the International Criminal Court makes a joint investigation team, but this is perhaps just a nice propaganda coup, but because technically there is complementarity, and so if Ukraine can go do it, then the ICC will simply not have to do it. And I don't think at this stage the prosecutor can say that Ukraine is either unable or unwilling to prosecute war crimes. Now, those people who are not in Ukrainian hands, they may be in other in the hands of other countries willing to apply a universal jurisdiction, and then I think complementarity works there too. If there's a state which is able and willing to prosecute, the ICC, even if symbolically all of us friends of the ICC, we would so much like if the ICC gets some cases. I think there are enough cases elsewhere, but obviously then when it comes to people who are not in the hands of the Ukrainians or Western states, then the problem will be to get them, and the International Criminal Court has better means than Ukraine to get them. Lessons learned from Bosnia and Herzegovina. Well, I hope there will be no ad hoc tribunal, because we have now the International Criminal Court, and obviously even in Bosnia, where there was an unprecedented effort to ensure criminal accountability, but please don't forget that accountability is not only criminal, and there need to be many other things to fulfill the rights of the victims than just criminal prosecutions. But, and this has also been seen in Bosnia, but I mean, Bosnia was nevertheless better than the past, where nothing happened. Now, one of the big problems, in my view, is again the mixing between jus ad bellum and jus in bello. Obviously, this is an international armed conflict. There's an aggression, but for the number of victims is 10 to 15 times lower than, say, in Yemen or in Ethiopia. And when we only look at IHL, then allegedly the rules in international and non-international armed conflicts are more or less the same. And even the rules on war crimes are similar. And so I would say this double standard cannot be justified by the fact that in one case there is an international armed conflict around it. Now, non-international armed conflicts in Ukraine, also before the 24th of February, there was a lot of discussion about to what extent there were both an international and non-international armed conflict. I think what happened, at least the mission considered that the republics of the so-called republics of Donetsk and Luhansk are proxies of the Russian Federation, and their conduct is governed by the law of international armed conflicts. Therefore, I'm not aware of other international, non-international armed conflicts in Ukraine today. While this was an important issue before the 24th of February. And finally, on the mercenaries, our finding is rather, first of all, I'm critical of Ukraine in many things, but here Ukraine did the right thing. All the volunteers from Western countries were incorporated in the Ukrainian armed forces, and so they are not mercenaries. On the Russian side, there are a lot of allegations about a Wagner group and so on, while their two most forces are incorporated into the Russian armed forces and are therefore, perhaps they commit more violations, which is not clear about the volunteers fighting on the Ukrainian side. But anyway, the accountability system is the same. And as long as there's a nexus with the armed conflict, the war crimes are exactly the same, and also the universal jurisdiction over war crimes is the same. Thank you.
Thank you. Any of the other panelists like to comment briefly?
I could just answer quickly that question, or there was a question about coordination of the prosecutors of universal jurisdiction processes in other countries with the Ukrainian prosecutor. I think definitely, and I think also very importantly, countries, especially, there are not so many countries that have actually taken such cases. Prosecutors between these countries that are taken universal jurisdiction cases should be cooperating between each other as well, because, but also, as I said, harmonization of their own national legislation, but also using then in coordination, using in cooperation the good practices of their colleagues from other countries on similar cases. All of this is very important. Of course, in terms of cooperating, coordinating or cooperating with Ukraine prosecutor, I must say, of course, this has to be done in a way that, depending on the case as well, of course, taking precaution for the safety and protection of the defense side of, the alleged perpetrator that is on trial as well, not to be harmful to the processes. And also one more thing to add is we forgot the Russian civil society, and we forgot, that they could be, to mention them, because they're going through tremendous pressure, as we know. If they're inside the country, they could face up to 15 years imprisonment for their work or closure. But I think in all accountability processes, and not only by the civil society in Ukraine, but also on the international level, I think we should reach out and we should engage the Russian lawyers, the Russian open source investigators, the Russian human rights defenders like the ones from Memorial, with all the experience they have from Chechnya and the work there. Of course, without endangering them, I would say the ones that are outside of the country. Similarly, the Belarusian NGOs that has just dealt with collecting information, many of them are outside Belarus, but they could be a very valuable partners in this.
Thanks, Marianne. I'd like to echo that, and I see there's also another comment in the chat, also making the same point about the importance of the role of civil society. And certainly, I think Russian civil society, as well as Ukrainian and Belarusian civil society, have a great role to play, and are playing a really important role in seeking accountability. Andrew, I think you wanted to come in.
Well, actually, there's a question. Somebody was asking if Professor Sassoli could comment on the reception by the report. So I was quite keen to hear that. I don't want to put my question now.
Thank
Shall
you.
I?
Please, yes.
Yeah. Well, I must say personally, I was astonished how positive it was. All participating states in Vienna were very positive about it, but everyone only mentioned our findings about the violations by Russia. Even Ukraine itself did not protest against the mentions of violations by Ukraine. So it was a very one-sided applause, but it was positive, and I wonder whether they all realize that if they are so happy with this report and with the legal theories which are therein, this could mean that the next time such weapons are used in Gaza, in Yemen, and so on, people will say, yes, but you were absolutely happy with this. Or the theory of functional occupation, which is admittedly quite large, we can only hope that next time this will still work, and this is not a la carte menu against Russia. But because it is important to remember that unfortunately we have currently, yesterday I tried to count them, 21 armed conflicts ongoing, some of which unfortunately provoke a higher number of victims than the one in Ukraine. Among others, also because Ukraine is a quite developed country and has a very good infrastructure, for instance, in terms of shelters, in terms of organizing food, electricity, re-establish basic services, and so on, which obviously is not the case, for instance, in Ethiopia.
Many thanks. And on that note, that universal note, I suppose I think we should close this discussion. I'd like to thank all of our speakers. It was a really enlightening and panel that I think we all learned a lot from. So thank you so much, and especially to Professor Sassoli, congratulations again on this this excellent report, and we really hope it will be the start of effective accountability for the violations committed in Ukraine, and also, as you said, will bring forward the push for effective accountability globally, and better coordination and better, stronger mechanisms for accountability globally. So thank you all so much, and thank you all to all of those who've attended and asked such interesting questions as well. Thank you. Bye-bye.